In a world where legal advice is no longer just privileged but politically sensitive, every document, draft, or email you send could be weaponized. Take, for example, the recent shocking development when Senior Advocate Arvind P. Datar was summoned by the Enforcement Directorate over his professional advice in the Religare case. Although the ED later withdrew the summons, the message was loud and clear. Even the legal sanctum is not off limits anymore. I am Dr. Arjun Chowdhury, advocate, and I welcome you all in this new episode of the White Collar Crime Legal Series. Today, we will discuss how lawyers and business professionals must safeguard their client data not just from hackers, but from overreach and misuse. Backing up an encrypted sensitive data is no longer a technical suggestion. It's a legal and ethical shield. The Arvind Datar incident is not isolated. Across India, lawyers, consultants, and CXOs are increasingly under the scanner not for what they did, but for the advice they gave. Now, the question is why this matters. The law may recognize attorney-client privilege, but authorities often use Section 50 of the PMLA, search and seizure powers, or digital surveillance to extract sensitive legal communication. With the advent of the Digital Personal Data Protection Act 2023, both lawyers and businesses can now be legally liable for leaks, breaches, or even unauthorized access to sensitive data. So if you are advising a client in a regulatory, tax, or criminal matter like Religare, Yes Bank, or even PMLA, you must protect every bite of that advice. Now the question is how to back up client data without compromising security. Step 1. Use encrypted automated backups. Trusted tools are Google Workspace, Vault, OneDrive for businesses, Acronis, or even Backbase. Follow the 3-2-1 rule. Free copies, 2 different medias, one stored offline or offsite. You can say cold backup. Step 2. Do not rely solely on the cloud. Cloud providers can be compelled to hand over data if not end-to-end encrypted. Keep at least one external encrypted hard drive in physical custody, locked, tracked, and audited. Step 3. Maintain confidential audit logs. Always know who accessed what, when, and from where. This is critical in case you are summoned or questioned, like in the Arvind Datar situation. You must prove that the client data was not tampered with or disclosed. Now let's understand the legalities of encryption and how to do it. It is the only reliable way to ensure that even if your data is seized, it remains unreadable without your key. So what are the recommended tools for encryption? File level, Encrypt, BitLocker for Windows, and File Vault for Mac users. Email, Proton Email, SMIME or PGP. For cloud, Tresorit, Sync.com or NodLocker, all end-to-end encrypted. So the best legal practices ensure all data systems are AES 256-bit compliant. Courts and regulators recognize this as industry-grade encryption capable of shielding against both breaches and unwarranted intrusions. And remember, if your device is encrypted, even a legal seizure may not unlock the content without your cooperation. And you have the right to remain silent unless compelled by specific court orders. For lawyers, I always say, create a fortress, not a folder. Lawyers should implement a data retention policy, delete what you no longer need, have NDA agreements with all IT vendors. Don't discuss sensitive matters over unencrypted apps. Even WhatsApp chats are now admissible in evidence. Step 3. Maintain confidential audit logs. Always know who accessed what, when, and from where. This is critical in case you are summoned or questioned, like in the Arvind Datar situation. You must prove that the client data was not tampered with or disclosed. Now let's understand the legalities of encryption and how to do it. For businesses, appoint a data protection officer under DPDP if handling sensitive or financial data. Enforce multi-factor authentication on all team accounts. Maintain legal privilege documentation so your in-house counsel's advice is not misinterpreted as criminal complicity. The next time you are advising a client in a controversial matter, remember you might not be a party to the dispute, but your laptop could be. In this new age of surveillance, sensationalism, and strategic leaks, client confidentiality is not presumed. It must be engineered. And always remember, encrypt, backup, protect, because legal advice is now as vulnerable as the evidence it is based on. This is Dr. Arjun Chowdhury signing off. Jai Hind.